I feel highly honored but down-spirited by the invitation to lead this lecture today. Mr. Chairman, on the eve of the independence of our country, it was consecrated to the sacred and immaculate house of our Lord Jesus Christ and our Mother, the Blessed Virgin Mary. This probably explains why Ghana has not experienced major mishaps. The returns from such a consecration are normally inestimable, as exemplified in the cases of the United States of America and Israel. Against this background, where Ghana stands now is a cause for grave lamentation. Ghana is heavily blessed in terms of natural and human resources, so one is justified to ask why the economic and social hardships. That said, my mandate for this lecture, as per my invitation letter, is in these terms: sharing my lived experiences with the justice delivery system vis-a-vis public confidence in the judiciary. 2, how recent judicial pronouncements and rulings portend for consideration of Ghana's democracy. This is against the backdrop that the African youth are increasingly losing hope in the democratic experiment and are manifesting same by pouring onto the streets to show support for military juntas to overthrow democratically elected civilian regimes. Indeed, the flyer on this invitation is in even wider terms: my lived experiences. Everything has a beginning. When I was in Form 2 in Notre Dame Secondary School, Nabrongo, our Latin master put before us a number of mottos for our choice. Some chose Orando et Laborando, Fidelis in Parvo, etc. I chose Justitia Omnibus, and I still love it. When I commenced my private legal practice at Bolgatanga in the then upper region of Ghana in August 1975, I soon realized that there was much corruption in the judicial system. By the grace of God, I stayed out of it, though it was very challenging. Should have been with me there, you see. My cousin could be a very good witness to some of it. In the wake of the 1979 revolution, a neighbor of mine was badly brutalized by some soldiers, and he sent for me to hear his story and see his condition. Despite the heat of the revolutionary atmosphere, I issued a writ against them, and they came to seek settlement. Unsurprisingly, their terms of settlement centered around smoking the peace pipe in the form of sharing a roasted fowl. I rejected this and kept to the writ. Unfortunately, their duties in Bolgatanga had ended, and they immediately returned to Accra. And my attempt to serve them with further court processes received no cooperation from their command structure. After the 31st December Revolution, I was appointed chairman of the then Upper Regional Investigations Committee, and subsequently also, briefly, as the acting special public prosecutor for the same region. I'll explain this. I actually moved in to do this for some time, because here was a revolution to cleanse the system of corruption, abuses of all kinds. My assistant was a very intelligent police officer, but his honesty was below sea level. So perceiving this, said, no, if I don't step in, this man will turn things back. So briefly, I stepped in and I was appointed acting special public prosecutor. That's for a brief period. In the course of time, a flight lieutenant from Accra came to Bolgatanga and asked why there were only a few cases for trial by the National Public Tribunal when it came to try cases in the upper region. I told him that the crime rate differs from region to region. He then asked about our investigation into the affairs of the then Farmers Services Company, FASCOM, of the upper region. I told him that our committee had spent 3 months thoroughly investigating that case and that we were not prepared to change anything. He went away. Now, let me interpose. There was so few cases. When the upper regional public tribunal was set up, before we commenced work, I was hearing on the airwaves people sentenced to 50 years imprisonment and all kinds of things. So I told them that you cannot right a wrong with further wrong. These kinds of sentences are too outrageous. And so I told them, and they agreed with me, that except in the very worst cases, nobody should be imprisoned. I was the prosecutor. In addition, one evening, a major of the Ghana Army from the Kamina Barracks in Tamale came to intervene in our committee's investigation into a case involving his nephew and his colleague officer who was temporarily stationed at Bolgatanga introduced him to me that evening. I told him that we would attend to him the next morning. The next morning, I had him called into our committee sitting room and had him sworn. I then asked what was his mission. He could not testify meaningfully. I then addressed him that it was they, the army, that launched the revolution to ensure justice prevailed. So how could that be achieved if they tried to obstruct the due flow of justice? He became uneasy and was glad to be told to go his way. He saluted us and left. These are a few episodes. I found myself appointed from the bar to the Supreme Court on 30th November 1995. I soon noticed that public confidence in the judiciary was of considerable concern in that there were perceptions of corruption and slanted judicial positions, especially in constitutional cases. There were frequent calls for the entire number of justices of the Supreme Court to be empaneled on constitutional cases. I proposed to try to unearth the causes for these perceptions, which were built up over the years. The perceptions were aroused by perceptions of political inclinations on the part of some judges. There is a long history to it. Sometimes the suspicion was anchored on the incidence of political influence. This occurred in various ways, various degrees, and at various times. Political confrontation. On 20th April 1970, the Court of Appeal, Quorum, Apalu, Cerebral, Sowa, Enin, and Archer JJA, gave judgment in Sala versus the Attorney General. It's reported in 2 GNG 739, second edition, 1319. The court upheld the plaintiff's claim for a declaration that his employment as a manager with the GNTC had been wrongly terminated by the Buzia regime. This decision meant that well over 350 other persons whose employments were similarly affected would also successfully sue the government. Before the court could hear the case, unsuccessful objections on the grounds of bias were raised against Apalu JA on the ground of close friendship with the plaintiff, and Sowa JA on the ground that his brother-in-law's wife had approached him to help her husband, Jonas, who was similarly affected as Salah by the termination of his employment. In the evening of that day, 20th April 1970, of the delivery of the judgment, an incensed Dr. Buzia, the then Prime Minister of Ghana, made a radio broadcast on this judgment, the full text of which is in 2 GNG 739, second edition, 1374. Inter alia, he filmed as follows, 1378 to 1379. Quote, if any others who were not reappointed in the recent implementation of the transitional provisions of the Constitution wish to sue the government, they are at liberty to do so. The government will not stop them. But if they hope thereby to coerce the government to employ them, then they will be wasting their time and money. My government will exercise its right to employ only those whom it wishes to employ. No court can enforce any decision that seeks to compel the government to employ or re-employ anyone. That would be a futile exercise. I wish to make that perfectly clear. This outburst flew in the face of Article 102 Clause 3 of the 1969 Constitution of Ghana, that, quote, in the exercise of the judicial power of Ghana, the judiciary in both its judicial and administrative functions shall be subject only to this Constitution and shall not be subject to the control or direction of any other person or authority, unquote. Article 115, Clause 1, Clause 1 and 2 of the said 1969 Constitution of Ghana provided as follows, quote, the Chief Justice shall be appointed by the President, acting in consultation with the Council of State by warrant under his hand and the presidential seal. The other judges of the Superior Court of Judicature shall be appointed by the President by warrant under his hand and the presidential seal, acting in accordance with the advice of the Judicial Council. Now, throughout my presentation, you will notice that there's always a difference between the mode of appointment of the Chief Justice and the other judges. That one must be by the President, advice in consultation with the Council of State. So, this has been the consistent thing. I don't know whether it's meant to kidnap the Chief Justice, administrative. Anyway, we shall see. Sorry. Consequent upon the judgment, this judgment, I read to you, Justices Atuguba and Apalu who after Olenu J.A. were the most senior justices of the Court of Appeal. See the list under the heading Judges of the Superior Court of Ghana contained in 1968 Ghana Law Report. E.A.L. Bannerman, who had been a senior magistrate, the equivalent of a circuit court judge, was appointed the Chief Justice of Ghana. And K.O. Labi, a private legal practitioner, and Cerebral J.A., the only judge who ruled in favor of the Buza administration in that Salah case, were made senior judges over them on the Supreme Court. What was more, VCRAC Crab, who in 1968 was the 11th most senior High Court judge out of a list of 12 High Court judges, see under Judges of the Superior Court of Ghana, 1968 Ghana Law Report, was appointed from the High Court to the Supreme Court as a senior over and above Azukrab and Apalu J.J. The appointment aroused public scrutiny as revealed in Bedu versus the Republic, 1974, Volume 2, Ghana Law Report 361. Thereat, the facts of the case are summarized in the head note as follows, quote, the appellant, the editor of a newspaper, the spokesman, published a front-page editorial commenting on the appointment of judges to the Supreme Court established under the suspended Constitution of 1969, which indicated that the appointments, including that of the first prosecution witness, as VCRC, were improper. The editorial also imputed that the first prosecution witness, who was at the material time the High Court judge, was unfit to hold the post of a Supreme Court judge, and that as interim electoral commissioner, he had, during the 1969 general elections, misconducted himself by showing bias in favor of the winning party. The appellant was therefore charged with intentional libel arising from the publication. Justice VCRC Crab turned out to be a very top judge. He was very good, very principled. But what raised the eyebrows of this editor of the spokesman paper was that he was almost the most senior High Court judge. Find Apalu and were on the Court of Appeal many years. When this Salah case came, went against the Bush. Then, former circuit judge made Chief Justice. This one brought as a senior to these ones. Again, the plaintiff in 24 versus Attorney General, 1980, Ghana Law Report 634 CA, sitting as the Supreme Court, successfully claimed that even though the 1979 Constitution preserved existing offices at the time it came into force, President Liman purported to nominate Apalu, who was the sitting Chief Justice, for parliamentary approval to be Chief Justice anew. Parliament rejected him on very tenuous grounds. Otherwise, Apalu CJ would have been ousted, and the Liman government would have had a free hand to pick the Chief Justice of his liking with his attendant implications. Let us see the politics in this. This man was retained by a clause of the Constitution which preserved existing offices. Very clear. Nonetheless, politically, he probably thought he was not suitable. So the man played the trick, I'm nominating you as my Chief Justice. By his politicians are waiting in Parliament to fail him in the vetting. Some of the things. And they did. If Dr. Tufo sadly understand he has passed, It can be a costly mistake to make, but I think he came to the Supreme Court and challenged this decision. Incidentally, the present president, if I recollect, Nchachu, were his counsel, and they succeeded in obtaining a judgment, retaining Apalu as the Chief Justice of the Republic, as the acting Chief Justice. But when they said most senior Justice of the Supreme Court got wind of it, he said, I'm quoting him, "You lie, I can act." When I heard that allegation, I was gravely hurt, since I have never in my life made any move to be appointed the Chief Justice of Ghana, because I consider lobbying for a position as a corrupt act, since it involves compromising one's conscience. Constitutionalism in Ghana. These sort of things do not augur well for constitutionalism in Ghana, which it is the primary duty of the courts to ensure. Our 1992 Constitution has ordained constitutionalism for Ghana. This is plain from particularly Articles 1, 2, 3, and 35 of the Constitution, which provide inter alia for the sovereignty and welfare of the people of Ghana, the supremacy and enforcement of the Constitution, and the blessings of democracy. Constitutionalism has been well explained by some eminent jurists in Ghana. In his very able book, Constitutional Law of Ghana, Text, Cases, and Commentary, Professor E. Kofi Abochi states at page 32 thus: constitutionalism as a concept can be defined as the limitation placed on the exercise of legal and political power. The concept of constitutionalism is peculiarly important for African countries, given the long-standing experience of dictatorship, anarchy, and misrule on the continent. As corollaries, constitutionalism and responsible government have been said to be mutually reinforcing. Constitutionalism promotes responsible government in the sense that it compels government to act in a manner consistent with expectations for the enforcement, for the conferment of power, and respond to feedback from the citizen. This is what is missing in Africa. I like that part where he says, constitutionalism promotes responsible government in the sense that it compels government to act in a manner consistent with the expectations for the conferment of power and respond to feedback from the citizen. In this context, one can accept that constitutionalism is a welfare-oriented concept to the extent that it seeks to ultimately champion the welfare of the governed by ensuring that governments exercise conferred powers in the best interest of the governed. It's brilliant and beautiful. This is what our Constitution has ordained for us. Is it happening? Very well. Also, in his thoroughly researched book, The New Constitutional and Administrative Law of Ghana, From the Garden of Eden to 2022, Professor William Atuguba states at page 2 as follows, quote, "The mere existence of a constitution is not enough for proper governance. A constitution can lead to constitutionality or constitutionalism. Constitutionality is the rule of law at the constitutional level, no matter what the content of the law is that rules. Constitutionalism, on the other hand, is good governance or people-centered governance at a constitutional level. With constitutionalism, there is limited government, people-centeredness, protection of minority and other rights, fairness, justice, equity, In countries such as the United States, which practice constitutionality and not constitutionalism, a constitution exists alongside social concerns like racism, gender inequity, and the prisons industrial complex. These are incompatible with the countries that practice constitutionalism. See also Professor Dateba's very scholarly book, Selected Papers and Lectures on Ghanaian Law, page 76. The appointment of judges, particularly of the Supreme Court, as the fulcrum of constitutionalism and the rule of law, has its hiccups. It is the Judicial Council that recommends suitable lawyers or judges for eventual appointment by the President. Sometimes, some judges are recommended by the Judicial Council to the Supreme Court over and above more experienced and senior judges, even though they are not more competent and experienced than their seniors. Often, when there is regime change, some of the sideline senior judges now get recommended for appointment to the Supreme Court through the same Judicial Council, but they then become juniors to their earlier juniors by reason of their later appointment. In practice, however, these later appointed judges often write the unanimous or lead judgments in difficult cases shortly after their appointment to the Supreme Court. Certainly, eyebrows can be raised over such practices. What can be the justification for such things? Nonetheless, depending to some extent on the judicial season, the judiciary has deepened constitutionalism in Ghana, notably the nullification of the 31st December holiday celebration funded from public funds, the freedom of choice of independent counsel by state bodies instead of the Attorney General despite Article 885, where there is conflict of interest. See Gyakye versus Attorney General 1, 2012, 1 Supreme Court, Ghana Law Report 679, National Media Commission, and Attorney General. So though that case delayed, but we unanimously held that the President had no power to appoint the persons managing the state, the statutory bodies managing the state-owned media. As stated by Professor Dateba in his third book at pages 17 to 18, constitutionalism is about having limits to the powers of constitutional bodies and enforcing those limits. The judiciary, through its exercise of the power of judicial review, is accordingly a vital actor in this process. The Ghana Supreme Court has been quite effective in protecting the legal framework of the liberal multi-party democracy, whose grown on in the 1992 is the 1992 Constitution. An example here would be appropriate. To my mind, this case illustrates the contribution of law to the development in Ghana. At first sight, the case, Huma Council versus Electoral Commission, Center for Human Rights and Several Liberties in the Attorney General and the Electoral Commission, 2010 Supreme Court Ghana Law Report 575, which was decided by the Ghana Supreme Court, would appear to have little to do with law and development. I don't know why I said that, but anyway. The main issue raised in the case, which in fact consisted of two consolidated cases, was whether prisoners were entitled to vote in spite of Article 42 of the 1992 Constitution, which provides that every citizen of Ghana, of 18 years of age or above and of sound mind has the right to vote and is entitled to be registered for the purposes of public elections and referenda. The Attorney General had argued in this case that it was in the public interest that convicted offenders are punished, kept under lock and key, and not allowed to vote. The Supreme Court rejected this contention and held that there was no justification for denying prisoners their unqualified right to vote. This right was conferred on all adult Ghanaians who are sane by Article 42 of the Constitution. As I said in that case, quote, that's Atuguba, not me. Nothing in the core values and spirit of the 1992 Constitution justifies the restriction on prisoners' right to vote that is advocated by the learned Attorney General. There is thus no basis for implying the restrictions argued for by the Attorney General to qualify the clear and unambiguous language of Article 42, unquote. However, it is lamentable, as pointed out by Professor Raymond Atuguba in his sterling book, that, quote, notwithstanding the Supreme Court departed from the proposition espoused by Atuguba in the Osei-Boateng case, decisions of the court after that departure still create doubt as to the current legal position. In some of these subsequent decisions, the Supreme Court seemed to be towing the line of the Atuguba JS in the Osei-Boateng case by declining jurisdiction to enforce the Constitution on the ground that the constitutional provisions sought to be enforced were clear and unambiguous. Notable cases are Mayor Ablese versus Attorney General and Asare and Attorney General and General Legal Counsel. Some other subsequent decisions of the Supreme Court have followed the reasoning in Novoko versus Attorney General. This turn of events creates a cloud of confusion and inconsistency in our jurisprudential space, making it difficult for one to tell the direction of flow of our country's constitutional law in this area. This must be a cause of worry to students and practitioners of constitutional law, unquote. Realistic independence of the judiciary. I want to emphasize that there is a vast chasm between independence of the judiciary in theory and its independence in practice. Thus, as explicitly stated by Dr. Atuguba in his aforementioned book at page 90, quote, independence of the judiciary has two dimensions, the institutional and the personal. Personal independence relates to the commitment of individual judges to the judicial values that ensure their impartiality and fairness. I'm here referring to values such as eschewing corruption and not allowing ethnic and other particularistic considerations to affect judicial determinations. Institutional independence of the judiciary, on the other hand, relates to the constitutional, statutory, and other arrangements put in place to assure the independence of the judiciary. Issues that are customarily dealt with under institutional independence include separation of powers, security of tenure for judges, including appropriate provisions on the appointment process of judges, the conditions of service of judges, and the process for the removal of superior court judges, financial and administrative autonomy for the judiciary. And measures are what make judicial independence justified. It will be unacceptable to have independent but unaccountable judges. Don't worry, I'm getting to the end. Is it lunchtime? Oh, all right, I'm finishing. I too need lunch. The James Gyakye Quayson's decision by the Supreme Court is, with all due respect, scandalous in that the court, in the teeth of the settled maxim res judicata et non quietem movere, re-adjudicated the same matter that has been adjudicated upon by the High Court on the merits. Never seen this type of thing in any judicial system. All that was left was its execution according to court processes. Again, the stress laid by the court on the statutory processes for acquisition and renunciation of citizenship shot itself in the foot. If the certificate of renunciation is so mandatory and conclusive, why was it not conclusive in its effect to qualify Gyakye Quayson when he received it dated 26 November 2020, whereas the parliamentary election was held on 7 December 2020? Statutes, judgments, and documents must always be applied with consistency, both in the letter and spirit. These must always be construed holistically and as instruments of justice, since it is a well-settled principle that the duty of a court is to do justice, and the court should not be turned away from doing justice. In the 2013 presidential election petition, 2013 Supreme Court Ghana Report Special Edition, 73 at 141, as stated as follows, quote, again in Osman and Tedam, 1972 G&G 1246, second edition, CA, and Osman and Kalio, 1972 G&G 1380, the Court of Appeal held that though the respondents were members of the Convention People's Party, whose constitution made all members of Parliament of the Convention People's Party members of the party's regional executive committee, that did not without more make the respondents members of such committees, and therefore disqualified to contest the 1969 parliamentary elections which they had won. Let me explain a bit here. Here was a decree that stated that all members of the regional executive committees of the then Convention People's Party were disqualified from contesting the elections. Literally taking it, it means if your name is on that list, you should be disqualified. But these judges bent on true justice said that, oh, but that alone cannot make you just a member. Then you should be, member means an active, must be attending meetings, doing service. So these people are not disqualified. We need such judges. The decision in Osman and Kalio is even more striking. Though the respondent has secured exemption from disqualification from contesting the parliamentary elections, it was submitted that since his exemption had not been published in the Gazette, upon which publication it will have effect under paragraph 3.5 of NLC Decree 223/1968, the same was inoperative. Notwithstanding that under paragraph 3.7 of that decree, the decision of the Exemptions Committee was final and conclusive. The Court of Appeal rejected that contention. Let me dilate a bit here. Here was a decree. Before the 69 general elections, some people, some ministers of the Buzia administration were investigated for corruption. Some were disqualified. But there was an exemptions committee. You could go before it and demonstrate that you were unfairly disqualified. So these two people went there and they had their exemption. But the law further went on to say that the exemptions committee, one was final, but paragraph 7 stated that it would have effect when published in the Gazette. So these people had their exemptions, but the Gazette publication wasn't there. And the opponents, politicians as usual, said, oh, they were not qualified. The strong court said that, oh no, I mean, this Gazette notification is just a ministerial exercise. The Exemptions Committee's decision is final, and that's the substance of the matter. As for Gazette, are these people responsible for that? So they upheld their elections. That's what I mean by substantial justice. Again, in Justice Dairy versus Tiger Eye, PI, and others, 2015 to 2016, 2 Supreme Court Annual Report 816, the Supreme Court unanimously held that though the impeachment process against the plaintiff was published in contravention of Article 146 of the 1992 Constitution, that could not vitiate the crucial impeachment procedures against him. In other words, the substantial and more important provisions on the removal of a corrupt judge could not be diverted by the incidence of the unconstitutional publication of the impeachment petition. This is substantial justice, serving the society properly. Just use a small technicality and walk away when video evidence is there portraying you as corrupt. Maybe sometimes some people would have upheld that. And that's the trouble. Similarly, then the certificate of renunciation dated the 26th November 2020 was more important than the anterior participation in Gyakye Quayson in the parliamentary campaigns between 5th and 9th October 2020 when he filed his parliamentary nomination papers with the Electoral Commission. The Supreme Court does not stand in good light, with all due respect, in disqualifying Gyakye Quayson, despite his clear certificate of renunciation of his Canadian citizenship as from 26 November 2020, whereas the elections were on December 7th. The certificate has come. Still, he should be disqualified. I'm not able to see substantial justice in this, as I've tried to demonstrate. By analogy also, in closer, it's a short form of a long title, versus Attorney General and 2 others, 2017 to 2018, 1 Supreme Court Ghana Report 210, the Supreme Court unanimously held that a member of the civil service or local government service can join a political party but cannot actively participate in politics or hold office as a political party nominee or remain in the civil service after election as a member of the district assembly. In other words, the operative evil to guard against is membership of the district assembly, not the contest of this for the same. Similarly, therefore, the operative evil to guard against about a dual citizen is as regards Parliament, his actual membership of it, not just the campaigns. That is why the Gyakye Quayson's case, his renunciation of Canadian citizenship certificate dated 26, 2020, is the operative consideration. In any case, it will be noticed that his certificate of citizenship is tied to an oath of allegiance. The two move together, the letter and the spirit. It is difficult to think that Gyakye Quayson, who submitted his renunciation of citizenship papers to Canada in 2019, could still, in December 2020, be held as seriously owing allegiance as a matter of hard realism, as opposed to formalism to Canada. In the King David example as cited in Asari versus Attorney General 2012, 1 Supreme Court Ghana Report 460, his Israelite citizenship You are modern, so you say Israeli. For us, we are like Israelite. That's in the Bible. Just your Israeli is not in the Bible. His Israelite citizenship became of real concern to the Philistines when going into actual war with Israel. Let me explain. David had fled from King Saul, who was always after him to kill, for he knew that God had anointed him to take his place. And that's where principle comes in. His own first son, Jonathan, saw that, our father, is it David's fault? This man staked his life against Goliath. You couldn't even do it. It's God who has anointed him. And we all know how he protected David against his own father. This is integrity. And when King Saul kept on pursuing David, he ran into the Philistine territory. They knew him, but they were fine with him because he was peaceful and all that. However, when they were going into battle against Israel, and he said he would go with them and fight for them, there they say, the king's advisor said, this man, no. During battle, he will side with his people. That is what allegiance points to, is the crux of allegiance. When they were staying peacefully with him, was he not an Israelite? Yes. But when the real danger was coming, hey, my friend, this is without your allegiance. That is how we should look at substance of the matter. Current image of the judiciary. Okay, I think I've exceeded my presentation. So what I'll do is, after this, I'll just summarize the rest, which is to follow, so that you don't complain that I punished you unconstitutionally, violated your fundamental human rights to fair nourishment and enjoyment and entertainment. I won't do that. Current public image of the judiciary in Ghana. The current public image of the judiciary in Ghana is reflected on social media. And here I'm referring to an article by one Dr. Lawrence Appiah, who has lamented the present state of affairs at length. He makes concrete points. The only warrant, I think, is likely to be a politician. He's saying that this current trend has to be reversed by Mahama when he takes over. That's why I suspect he's a politician. His points are good. That doesn't mean that we should rubbish them, as happens in this country. Somebody makes important points, they are good for the country. But those who are steeped in rapid politics will just rub you, oh, he's an innocent. That's right. This type of life. Where we are today, that's what happens when people become hypocritical, become stooges to the establishment. Oh, yeah, well, okay, I'll give you the reference on social media. You can access it. That's where I also saw it. Where did they publish this thing? Yes. Ghana News Online.com, 16th October 2023. That's where you can find it. Go and read it. He makes points. He's actually complaining about certain things. How a motion to arrest the closure of the limited EC registration was pushed listed for 17th October when the resignation exercise was to end on 2nd October. He has pointed out all these things. I mean, I don't know. Anyway. He has also, oh, you go read, you see also, as I said, want you to go and eat. Another thing I refer to is an article by Michael Quay, the former Speaker of Parliament. Let me give you the online reference. This one is on myjoyonline.com, 28th April 2022. Now, shortly, he was saying that the executive can do whatever it wants when it wants to remove a judge. He was referring to Amosechi JS. And he's saying that the appointment procedure for the courts should be streamlined to avoid such things. Here, let's see. This Amosechi, well, it's unfortunate he tendered his resignation because I was on the committee to investigate him. And I tell you that he needn't have done that. Can't say more. But before I was aware, he left. Now, his exit from the judiciary is a great worry to some people. What of others? See, wrongdoing cuts is like a double-edged sword. You think you are using to cut your neighbor, you don't know when it can come back to cut you. That's why the best thing is to be fair, steadfast. In principle, everybody will be satisfied. Politicians, that's not their cup of tea. Let me conclude now. I'll read the conclusion. It's very short. So, your lunch, getting very close. Mesumi Peg. I can't speak this fine language, but I think I've said it correctly. Now, one of my colleagues said one lawyer went to a chop bar, I think at Kumasi, and then his client happened to go there, so I said, lawyer, what's so bad? By me, I go to all kinds of places, there's fine food. Now, this is my conclusion. In view of all this, what matters most is the realistic auditing and restructuring of the judiciary, and indeed all other governmental institutions, because just as the cyanide of illegal mining galamsey has devastated our forest lands and poisoned our water bodies, so also has the cyanide of political corruption poisoned our governance institutions. Appointments to the judiciary or any other governance institution must be made by thoroughly independent bodies based on nothing but merit and not on things like protocol, chronism, ethnicity, or other improper considerations. Now I have a problem. Maybe some of you can help me to solve it. There's an advertisement for employment into an institution. The criteria are set out. Now understand there's something they call protocol. How does it fit into the scheme of criteria? Protocol, so it's also a qualification? I can't understand. But here it's happening a lot. This type of thing. And Ghanaians too, I'm sorry. I mean, generally Ghanaians like cutting corners. They're looking for something. Oh, know that man. It's not healthy. You can do that and get in. Your son or your relative, even it doesn't matter who he is, a human being, is obstructed, although he has sterling qualities, stepped aside, and some mediocre person is put there. How does that help this country? It's happening. Service conditions must be reasonably attractive, and presidential and other political pressures. Security of tenure of office must be enshrined. The executive powers of the president and his functionaries must be drastically curtailed. There must be real separation of parliament from the executive branch. The emphasis should be on good and sincere governance in the interest of the people and not on hollow, over-exaggerated notions of electoral conferment of power on anybody or group of persons. Now, see the democratic process as it is being practiced. Is that the democracy the Constitution has ordained? Is that what we want? To me, it's just used as a smoke screen. In front of it, values and principles are preached. Behind it, it's deep-seated subversion of all. But no meaningful political reforms can be reasonably expected, even under a regime change, without sustaining the political renaissance which has started and is going well in Ghana. That's why that's why I've agreed to come, because I lost hope. But when I see these young people, I've never seen him. I hear he's here. Can you favor me with me seeing you? But be careful with politicians. You see, enthusiasm, you should do it, even as I'm saying here, hey. But, see, if you throw a careless statement, get at you have no defense. So just keep to the principles, insist on the principles, without falling to the temptation of the kind of pedestrian political garbage that is spewed out on our airwaves almost every day. That aspect is not necessary. It is for this reason that I would like to acknowledge, encourage, and congratulate nationalists like Kwesi Pratt. I've never seen him, but I've always praised him. This is not the first time. I did so at Cape Coast when I was launching a book in 2020. Dr. Arthur Kennedy of the USA. This man, if I had my way, would have been a model president for this country. I think he followed his activities. Very principled, fair-minded. But when he contested MPP presidential, I understand he had only one vote. You see? This is a kind of politics we practice. Very sterling man. You should get away. And then you bring some, even say some places, you put a stone, we vote for a stone. Now today, the effect of voting for stones. Dr. Arthur Kennedy of the USA, Dr. Jampo, I've never seen him, but I followed on social media. I understand he's in the political science department. Yeah. You see here, I don't think so. I'll find time and get to know him. He's a proper man. Very fearless and impartial. That's the important thing. Professor Bokwin, I've seen it on social media. Some handsome young man. He's a prof already. He's steadfast. Is in this university? Yes. Okay. Okay, I'll try to know him personally and encourage him. I'm so enthused by his nationalistic stance. Professor Ajmandia of the Center for Democratic Development. I've never seen him, but on social media. Like him. Recently, I hope I've got his name right, Dr. Asariba is a retired lecturer in the KNUST Political Science Department. Amoakoba, thank you. I was wondering whether I'll correct it. Yes, but I said recently. You see, recently. Kwame Pianim. Sterling man. Unfortunately, I had to disqualify him at my first constitutional case on the Supreme Court. Fine man. When I saw him, I said, oh, very nice man, both physically and from what I heard about him, popular. But then he tried to stage a coup, and it didn't work. And the Constitution disqualified people who indulge in acts inimical to the state security. So I had no way we were three in the majority. I was one of them. I just come to the Supreme Court. But I like him. Actually, I've been following his this on this. Dr. Nyaho Tamaklo. I've never seen him, but it's another. Kevin Taylor. I've praised him before at Cape, but I said I don't know why he will not just make his point, but indulge in invectives. I mean, it's not necessary. They are making concrete points. Those with, slanted positions will just say, oh, but how do you take him seriously? You see? He can make serious. I don't know where he gets the information from. I'm in Ghana. I don't know most of the things he's saying. Those things will help us. But then he will insult and insult. Why? People will just use that to say, oh, see? All right. Emmanuel Wilson, my friend, Jr., the chief crusader against corruption in Ghana. I've added in pen the Ghana National Conference of Catholic Bishops. Those of you who are Catholics, I encourage you, always buy the Catholic Standard every Sunday. You see a lot of sound principles there. And they are steadfast also, fearless. I'd like to congratulate the staff of that newspaper, the Standard. They are consistent. They don't toy with facts. No. Unfortunately, I was overtaking my time. I saw one recently, one Reverend Opuni or so. I think you've seen him also on social media. Reverend Opuni. Yeah. Yes, very, very forthright man. Well, I don't know most of these people I have mentioned personally, but I followed their works on social media, and I'm impressed. However, I hope that they remain nationalistic no matter the regime in power. That's very important. Because if some of them are just doing it because they are opposed to this president, that's not good enough. If the next regime comes, even if it's your own party, you have to remain like that if you are to be true and sincere to Mother Ghana. Then we'll get somewhere. I also wish to acknowledge some of the many civil society organizations, such as Ghana Center for Democratic Development, Ghana Integrity Initiative, Citizen Ghana Movement, Africa Center for Energy Policy, Parliamentary Network Africa, PEM Plus Bites, Media Foundation for West Africa, Send Ghana, One Ghana Movement Center for Democratic Development, Democracy Hub, Occupy Ghana, an Institute for Democratic Governance. I don't know most of this, but where I've got this list from, this case, they were the people who brought the constitutional action in favor of Domelevo. That's why I got these names from the title of the case. And it shows where civil societies have gotten to. And that is what can help this country. Okay, so it's lunchtime. Thank you very much.
For more news, please visit our website, graphic.com.gh, or follow us on Facebook at Daily Graphic and on YouTube and Twitter at GraphicGH.
Subscribe now.